Good morning.
Good morning, Your Honors. May it please the Court, my name is Mitch Raines with the Public Defender's Office here for Ms. Phillips today. At this point, I'd like to reserve 4 minutes for rebuttal. Thank you. Before I begin, I would also just like to note a typo in my principal brief. I included a chart that was meant to be a summary of the offenses and the sentences that were imposed. For count 6, I have that listed as a 20-year sentence, but it's a 10-year sentence. So if you look at the chart and the math doesn't math, that's why. So for a little bit of background, this case was tried on October of 2021. There were 6 counts: aggravated assault, 2 especially aggravated kidnapping, 2 aggravated child neglect, and a carjacking. And the total effective sentence that was imposed was 30 years, and that would be with no release eligibility. The basic facts are that in March of 2020, as the state put forward in its case in chief, there was a Mrs. Hibbard and her 2 sons stopped to pick up some takeout from a local restaurant. Ms. Hibbard left the children in the car when she went inside to pick up the food order, and as she was returning, encountered Ms. Phillips, who got into the car, drove away a short distance, stopped, picked up a co-defendant who was Brandon Phillips, and then the mother tried to get into the car. They drove away again. She got drugged for a short distance, and then they abandoned the vehicle and the children roughly about 3 blocks away, and the children and the vehicle were recovered, I believe, within 30 minutes. It might have been quicker than that. I've raised 2 main issues on appeal. They deal with the sufficiency of the evidence of the aggravated child neglect, and then also the sentence that was imposed by the original trial court. As to the sufficiency issue, there are 2 points that I'm trying to make there. The first is that a deadly weapon, as applied to the children, capable of causing serious bodily injury, was not used in this case. So that's kind of a mouthful. It's got a bunch of parts to it. But the main point is that there has to be a dangerous instrumentality. And in this case, I concede that under the right circumstances, a vehicle could be a dangerous instrumentality. But there's more to the equation than that. It has to be viewed as applied to the children, and then if it's capable of producing serious bodily injury. Here, the argument is that, yes, a vehicle was used under the right circumstances that can amount to a dangerous weapon or a deadly weapon, but as viewed applied to these children, it does not qualify as a deadly weapon or a dangerous instrumentality. And that's because Ms. Phillips did not use the vehicle in a manner that was capable of inflicting serious bodily injury on these children.
So you're saying unless she tried to run them over, the car would not be, you couldn't term the car in that way?
In its most basic form, yes, Your Honor. That's what the statute was designed to punish.
So you're saying under no other circumstance, using a car, driving recklessly, leaving the children in this car in a strange place, that wouldn't rise to the level of dangerous instrumentality? No,
Your Honor, because as applied here, in this case, that's not capable of producing a serious bodily injury. The children were inside of the vehicle. When we talk about driving recklessly, certainly Mrs. Hibbard was in a position to be injured by the vehicle.
So
she's outside of the car at that point.
Occupants in the car, if someone's driving recklessly, are not in danger?
I don't think under these circumstances. The reckless driving is really only applicable to Mrs. Hibbard holding onto the vehicle and being drugged. But there's no indication that, they were flying around downtown on these narrow streets at a high rate of speed or any of those kind of things. Jumping curbs, that sort of stuff that would have amounted to a reasonable expectation of a serious bodily injury resulting to the children who were in the car in the back in their child restraints.
But wasn't the car used as the instrument to separate the children from their mother, which is the harm that the kidnapping statutes are designed to prevent, because of the horribly dangerous situation? I mean, it's every parent's nightmare.
That's true. There's a distinction, though, Your Honor, between the kidnapping statute and the aggravated child neglect. So I'm challenging the child neglect in this case, and it requires that a dangerous or a deadly weapon be used as applied to the children that's capable of inflicting serious bodily injury. So the second part of the argument is that the harm that the children suffered here, and they certainly suffered a harm. I'm not trying to say that they didn't. There was a psychological effect that occurred to these children, but it's not to the same caliber that the statute was designed to prohibit at the time that these offenses took place. The statute there defines the harm or the harm as being equatable to female genital mutilation, severe dehydration, starvation, those sorts of long-lasting physical effects that could be imposed upon a child. And we don't have that here. There was certainly a harm, but it doesn't rise to the level of the harm that was intended to be punished by the aggravated child neglect statute. If there are no further questions about the sufficiency argument.
There was a co-defendant,
There was a co-defendant, Your Honor.
and has that case been appealed?
It has. So Mr. Phillips had separate counsel from Ms. Phillips. She had retained counsel. Mr. Phillips,
I guess the question was this issue raised in that appeal also?
that's something that the state has brought up. They try and argue that under the law of the case doctrine, that Ms. Phillips should be prohibited from raising this argument about a deadly weapon and its use. As I explained in the reply brief, though, that would, one, be a novel application in this case. This is a case that's a little bit procedurally off-kilter, I suppose. They were tried together as co-defendants. Mr. Phillips timely filed a motion for new trial. That was denied, and then he took his case timely on appeal to this court. Ms. Phillips's retained counsel, short form, was not properly notified.
Here's the other part then. So,
Yes.
but the same charge in that case was upheld on appeal?
It was not, my position there is that it was not framed the same as I'm doing here in
Same
this case.
charge was
The
upheld?
same charge.
Was
yes.
upheld on appeal?
Yes, Your Honor. They had the same
Now,
convictions and the same
you
charge.
may have different arguments than they may have had, but
Yes.
certainly that may have some, I may or may not agree with the state's counsel with regard to the law of the case. I'm just saying, certainly it would perhaps be some persuasive authority for this court to consider.
I don't think so, because the arguments are not the same.
Okay.
The charges are the same, yes, but the arguments are not the same. Mr. Phillips primarily argued
But
for...
allegedly, the facts would be the same.
Yes, but again, if this court's not directed to the same argument that's being made, I don't think it's appropriate to say that the same result is automatically...
I never said that. I'm just saying.
I understand that. I just want to make that point clear. I think that Ms. Phillips' argument is unique and distinct from Mr. Phillips, and that this court should review it based on its merits. Moving to the sentencing arguments, there are two there as well. First, that consecutive sentences were improperly imposed under Wilkerson, and also the trial court failed to consider a mandatory mitigation factor, specifically that the kidnapping statute requires a court to consider those offenses to have some mitigation effect if the victims are left alive.
And that mitigation would only apply to counts 2 and 3,
Now-
right?
now,
That's correct.
And the question that I was going to ask with regard to that, the statute uses the term voluntary release.
Yes,
right?
yes.
Okay, so if you're in a car and you've allegedly taken somebody in a car, and these are children, obviously 3, 4, 5, 6 years old. Okay, if you're abandoning the car that you've allegedly taken without permission, is that a voluntary release?
Yes.
Because the case law says that it is?
It's, I think just from a
In other
practical...
words- Go ahead.
I think just from a practical standpoint, to release the victims alive, to relinquish your captivity over them is the point of the mitigation factor.
Is there any case law that talks about that at all that you're aware of?
Not that, I've not looked at that specific issue, so I'm not, I can't say yes or no. But to me, it would say The point and the public policy behind the factor, which is very clear, is that there is supposed to be an incentive for people who engage in kidnapping to leave the victims alive. So applying that public policy interest to the mitigation factor, I think that here we can say we have a voluntary release. The children were abandoned in the vehicle, and obviously they were left alive. So because of that, Ms. Phillips was entitled to some mitigation effect on her sentence for the kidnappings.
So it's leaving very young children alone in a car in a strange place where they could get out and maybe wander into traffic would be considered
The mitigation factor does...
voluntary release?
The mitigation factor just says it has to be a voluntary release and they have to be left alive. It doesn't go so far as to say that they have to be in good health or that it has to be the best possible way to release the victims. The main thrust is really we want to provide an incentive to people who engage in kidnapping to release victims alive. So I think that the legislature intentionally left that mitigation factor broad so that it could have broad application, again, because that public policy concern is so important. The state, to that point, has argued also that this factor or consideration of this factor has been waived because at the end of the sentencing hearing, the trial court asked if there were essentially any other follow-up questions, and retained counsel responded no. I would first point this court to the transcript hearing where early on retained counsel argues that there is basically some mitigation effect given that Ms. Phillips abandoned the vehicle and the children unharmed relatively quickly. That's kind of a loose quote. So I think that by any reasonable measure is trial counsel asking the court to consider this mitigation factor. And the trial court is explicit in that it finds no mitigation at all. It does not specifically address this mitigation factor as I argue is statutorily required. And if this court wants to engage in a waiver analysis, I think that this court's fairly recent case in State versus Ross is a pretty good example of how to handle this. In Ross, there was a risk and needs assessment which was statutorily required, but it wasn't performed. And this court went through an analysis, as I've explained in my reply brief, that ultimately found that it was a statutory requirement that a risk and needs assessment be performed and that the trial court had an obligation to consider it, even though it didn't say how much weight that it had to give it. And because of that, this court ultimately remanded. And it found that there wasn't an affirmative waiver. And I don't think that we have an affirmative waiver in this case either if you have retained counsel asking for some mitigation effect to be provided by the fact that the children were left unharmed relatively quickly.
And Mr. Raines, you're saying in this case that should be the remedy on these two issues, a remand for a new sentencing hearing?
I think that is probably the best recourse in this case. As to the Wilkerson factors, the state has conceded that there were not sufficient factual findings to support that, and this court has said time and time again that in that situation, its preferred practice is to remand to the trial court. It's a little bit of a different case here because the original trial court has retired. We have a new trial court that's in place, but that trial court did handle the motion for new trial and said that it was pretty well versed with the record. So I ultimately think the more standard course of action would be to remand, but this court could address the issue on de novo. And if it did, I think reviewing the Wilkerson factors and applying them to this case, it would find that consecutive sentences aren't required. That an all concurrent sentence of, I would request 15 years also given the mandatory mitigation that's required for the aggravated kidnapping to be served at 100% would be more than sufficient punishment for these offenses. But I do recognize that the general tendency of this court, or the general rule, is to remand for a new sentencing hearing. If there are no further questions, I reserve my time. Thank you.
Good morning, Your Honors. May it please the Court. Benjamin Barker on behalf of the state. Your Honors, this court should affirm the defendant's convictions and sentences because the evidence was sufficient to support her convictions for aggravated child neglect. And the trial court properly exercises discretion as to the sentence length, and on de novo review, the record absolutely supports partial consecutive sentencing. Judge Campbell, if all of this has sounded familiar to you, I think it should, because you were sitting in that very seat when this court heard Brandon Cody Phillips, the co-defendant's case, in which the court found that the car here was a dangerous instrumentality. And so it's the state's position that this court should invoke the law of the case, whatever you want to call it, doctrine, to bar relitigation of this sufficiency claim. Now, yes, the specific contours of defendant's argument here are a little different than the way the issues were framed in Brandon Cody Phillips. But this court still decided the same issue ultimately, whether the car was a dangerous instrumentality, and concluded that it was. I point to one Sixth Circuit case in the state's brief, using this doctrine to bar relitigation of a claim where the co-defendant in a prior appeal made the same claim. And if this court would like a letter of supplement authority, I digged a little deeper and found several other federal circuits have used this same doctrine to preclude defendants or co-defendants from raising identical issues in separate appeals. I count the 10th Circuit, the 1st, 4th, 9th, and 11th. Ultimately, it's the state's position that this court should invoke law of the case here and preclude litigation of this claim. But in any event, the evidence was just sufficient. The car was a dangerous instrumentality here, and I don't want us to add requirements to the statute that aren't there. The statute requires that a dangerous instrumentality be used to accomplish the act of neglect. It doesn't say that the dangerous instrumentality has to be used to inflict the neglect, or it has to be a dangerous instrumentality as applied to the victims. It just says that a dangerous instrumentality was used to accomplish the act of neglect. That's really broad. And here, the car absolutely was a dangerous instrumentality, as this court has already concluded. It was a dangerous instrumentality during the drive when defendant drove recklessly. If defendant had tried to run the children over with the car, well, yes, that would certainly be dangerous, but we wouldn't be in neglect world anymore. We might be in attempted murder world, but it certainly wouldn't be an act of neglect. Here, the car was a dangerous instrumentality as to the occupants, as it was driven recklessly. Defendant very well may could have gotten in a wreck, flipped the car. That certainly would have been dangerous for the occupants. And here, defendant could not have accomplished her act of neglect in leaving the children in this empty lot by themselves, away from their mama. The car was central to that act of neglect, so it was used to accomplish the act of neglect.
So, I'm sorry, Mr. Barker, just to interrupt you for a moment there. In the statute, 3915.4.2, the definition of dangerous instrumentality says, a dangerous instrumentality is any item that in the manner of its use or intended use as applied to a child is capable of producing serious bodily injury to a child, as serious bodily injury to a child is defined from this section. So when you read that, are you saying it doesn't matter about the facts of that particular case, that a car, since it could, in the manner of its use or intended use as applied to a child, cause serious bodily injury, then a car is always going to be a dangerous instrumentality? Or do we look at the facts of that particular case to determine, in this case, was the car actually a dangerous instrumentality?
The court would have to look at the facts of this case. I think I should have read a little further down the statute before I continued this morning.
Well, that's what your friend on the other side is arguing, that in this case it wasn't used in a way to harm the children, and that's what I'm thinking about too. And I agree with you on that definition. So I'm struggling with the way it was used in this case. was the car placing the children in a position where they're going to suffer serious bodily injury because of the use of that car?
I think so. The car amplified the danger of the neglect, especially for the younger child who was still, strapped into the car seat, helpless to do anything about whatever danger, might arise. And then also for the older child who, kind of wandered off, I think he said, in search of the bad guys to tell the police where they were when they arrived. So I think, yes, the car was a dangerous instrumentality here because it amplified the danger of this neglect for these children. And beyond that, the proof also established that the children's health and welfare were adversely affected. That's all the statute requires. As I point out in the state's brief, there are these other, other factors that have been added, I think, since these offenses were committed to the statute, with the starvation, the mutilation, all of that. It just does not have to be that bad to adversely affect a child's health and welfare. And here, the children's health and welfare were adversely affected. The children were crying for their mother. They were scared and shaking. They couldn't sleep in their own bed for about 2 years after these offenses were committed. And Mrs. Hibbard, the mother, recognized that the older child needed counseling, but just was unable to take him to any sessions. That doesn't, just because the victim didn't avail himself of the treatment that he needed, doesn't mean that his health and welfare wasn't adversely affected. So the evidence was just sufficient here. As to sentencing, first as to length, on reading the record with fresh eyes, this issue was preserved. Defendant's counsel asked the trial court to consider that she, quote, abandoned the car and the kids unharmed very quickly. Then the trial court said, quote, considering mitigation, I find little, if any. The way I understand that is that the trial court considered the factor and didn't afford it any weight, which this court has said time and time and time again is not a basis for appeal. So the issue was preserved. The trial court just didn't give this mitigating factor any weight, which it was entitled to do as a trier of fact at sentencing. Now, as to alignment, the Wilkerson findings, unfortunately, are just not there. But if there were ever a case for de novo review instead of remanding for a new sentencing hearing, this is it. And also, if this court's going to engage in de novo review, then the record is wide open for this court to rely on whatever supports that sentence. And there's no need, really, to even get to the Wilkerson factors here, because other factors support partial consecutive sentencing. Namely, that defendant committed these offenses while she was on probation, and she also had an extensive criminal history. I don't read the record as the trial court specifically declining to apply, this probation factor. It just kind of applied Wilkerson and moved on the way I read it. And also, if you look at the pre-sentence report, defendant has been getting in trouble with the law for her entire adult life. It's multiple pages of the pre-sentence report that are her criminal record. So,
And as I recall, Mr. Barker, was there another basis for consecutive sentencing besides Wilkerson, or besides that dangerous person with little regard to human life, or was that the only basis for the consecutive sentencing?
I yield to the record as I remember. That was certainly the only basis in the trial court's kind of checklist of findings and fact and conclusions of law as to sentencing that's in the technical record. But multiple factors support partial consecutive sentencing here. Ultimately, defendant kidnapped 2 children as their mother stood feet away, and then dragged her down the road when she tried to apprehend them. Then, when this defendant was tired of joyriding around downtown Oneida, she abandoned the car and the children in an empty lot in bad weather. An effective 30-year sentence is reasonably related to the severity of these offenses and is also necessary to protect the public from further criminal acts. If this court has no further questions, we ask that you affirm. Thank you, Your Honors.
All right, Ms. Raines?
Thank you, Your Honor. Just briefly, Judge Sword, to your point, I think it's well taken that we have to look at the full scope of the statute for aggravated child neglect as it existed at the time. And so there it says that there has to be a dangerous or a deadly weapon as applied to the children that's capable of inflicting serious bodily injury. And so again, I think that that's a fact-intensive review that this court has to undergo, applying that statutory language to the facts of this case. And again, I just don't think that using the vehicle to remove the children from their mother is what the statute was designed to prohibit in this case. As it's applied to the children, it's not capable of producing serious bodily injury in this case. I would also just note that there is, time and time again, the state brings up the issue that one of the children said that he got out of the car and ran after the bad guys. That is something that the mother, Ms. Hibbard, relayed at trial. There is conflicting information from one of the officers, the first one to arrive, who said that he found the child standing in the back seat and that he got him out of the car. For whatever that distinction is worth, I just think that it's worth bringing up. The state also argued that the harm in this case does not have to be as bad as female genital mutilation, dehydration, starvation, but those are the examples that are listed out in the definition that was applicable at the time. And so I think to read something much further than that, something that is not in the same category of harm to support this conviction would not be appropriate. When the legislature uses these specific terms, it didn't provide an exhaustive list, but it does set the kind of expectation for the harm that it's trying to protect against. And it's to a degree of magnitude much more significant, I think, than what the children suffered here. Again, not to say that they suffered no harm, but I don't think they suffered the kind of harm that the statute was designed to prohibit at the time.
So are you saying that there has to be harm? I mean, physical harm or emotional harm, or maybe I'm misunderstanding what you're saying.
Under the definition, I think it's for serious bodily injury. At the time, it defined harm capable of producing harm. There doesn't have to be a harm, but it has to be capable of harm, and it has to be, I think, comparable to the specific instances that are provided in the definition, which include female genital mutilation, dehydration, starvation, which are, I mean, I recognize that there's...
I think the state suggests that the harm also may have been driving the vehicle recklessly with the children in the car, too, right?
I don't think that that is applied to the facts of this case. I don't think that that was that meets the requirement of the statute, right? It's a dangerous weapon as applied to the children that's capable of producing serious bodily injury.
So at trial, did the state argue that that the harm was the emotional part of what the children experienced? That was their reason for finding that it was a dangerous, or saying it was a dangerous instrument?
Everyone pretty well agreed, I think, that a vehicle can be a dangerous instrumentality, right? There's plenty of case law, especially in aggravated assault context, that shows that a vehicle, if misused, can produce a serious bodily injury. I certainly don't argue that Ms. Hubbard wasn't exposed to that. That was kind of the argument made for her aggravated assault claim. But again, as it's applied to the children here, there's nothing to show that Ms. Phillips' use of the vehicle to remove the children from the mother, that's really what causes the harm, is the removal of the children from the mother. And I make the analogy in my brief that that's no different than if she had picked the children up and ran away, right? Are we going to say that her shoes as the means of conveyance are a dangerous instrumentality?
Her shoes don't weigh 2 tons, though.
There's case law, though, that establishes that shoes in the right proper context can inflict a serious bodily injury. It's the same kind of, to me, it's the same kind of analogy.
Yeah, I just remember that the co-defendant's case, though, he looked at the car and found that it was a dangerous instrumentality.
And I don't dispute that. I think that a vehicle can be a dangerous instrumentality, but as I've talked about, there's more to the analysis than that, and it has to be a specific factual analysis here as applied to the children and incapable of producing serious bodily injury. And I just don't think that Ms. Phillips' use meets that definition. Recognizing that I'm over time, I apologize for that, and I ask this court for the relief requested in the brief. Thank you.
All right, thank you. Everybody okay?
Yep, I'm good.
Madam Clerk, would you call the next case, please?